Hello, everyone, and good afternoon. My name is Richard Joy, and I'm the Executive Director for ULI Toronto. On behalf of ULI and Shared Path, I'm pleased to welcome you to today's session, Whose Land and Whose Law? Indigenous Land Rights in the Greater Golden Horseshoe, examining the duty to consult and accommodate. As a Toronto-based organization, we acknowledge the land we are meeting on, if virtually, is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, the Wendic peoples, and is now the home of many diverse First Nations, Inuit, and Métis peoples. We acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. We are grateful to have the opportunity to work on this land, and by doing so, give our respect to its first inhabitants. To better understand the meaning behind this land acknowledgement, I recommend a program that we hosted with Shared Path over the summer called 13,000 Years of Indigenous History in the GTA and Why It Matters to Planning and Development, the link for which we will post in chat. Before we begin, I'd like to go through a few housekeeping items. Everyone will automatically be on mute. If you are experiencing any issues, please direct them to the chat box. There will be a Q&A session, so please be sure to submit your questions via the Q&A function on the bottom of the screen. There's a thumbs up or like function that allows you to upvote a question that you would like answered, which we also encourage you to do so we can make sure that we're addressing the top questions via democratic vote. The session is being recorded and will be sent to registrants in the coming days and will be made available on ULI's Knowledge Finder platform in the next few weeks. If you want to take the conversation online, please tag us with the handle @ULI Toronto or by using the hashtag #AskGreatQuestions. Today's event and other ULI programming would not be possible without the support of our annual sponsors. I would like to say a major thank you to all of them for their support. ULI Toronto relies on the support of our sponsors who allow us to put on the quality programming due to drive our mission of creating and sustaining thriving communities. To all of them, we say thank you. I would also like to acknowledge our partner in this program, Shared Path. You'll hear more from Morgan at Shared Path at the end of this call, but this program wouldn't be possible without their support in so many ways. It is now my pleasure to introduce the moderator for today's session, Ron Williamson. Ron is the founder of Archaeological Services, Inc., a cultural resource management firm based in Toronto. Ron is the vice chair of Shared Path Consultation Initiative, and he has published extensively on both Indigenous and early colonial Great Lakes history. In 2016, he was conferred the Smith-Wintenberg Award, the Canadian Archaeological Association's most prestigious award for outstanding contributions to Canadian archaeology. And in 2019, he was given Heritage Toronto's Lifetime Achievement Award. Ron, I'm going to now pass things over to you and to get our panelists introduced and begin today's session. Over to you.
Well, thanks very much, Richard. Good afternoon, everyone. I'm absolutely delighted to be joined in conversation by Renée Pelletier and Adam Chamberlain, both of whom are good friends and colleagues that we have worked together many times. I'm going to ask, actually, Renée and then Adam to say a few words about themselves, thereby introducing themselves to all of you.
Thanks, Ron. Hi, everyone. I'm really delighted to be here. I'm looking forward to this conversation today. So as Ron mentioned, my name is Renée Pelletier. I am the managing partner of a law firm called Otheus Clear Townshend LLP. We are based out of Toronto. We have an office in Yellowknife as well. We are, I think, now considered the largest Aboriginal rights law firm in Canada. So we do exclusively First Nation and Indigenous side Aboriginal rights. My practice involves, involves a lot of things. Sort of two of the main things are I do a lot of work working with First Nations and Indigenous groups to help them safeguard their rights and interests in the context of development. So sometimes that means working with them, appearing before regulatory tribunals to have their concerns known to for project development, things like the National Energy Board, or before the Canadian Environmental Assessment Agency, now the Impact Assessment Agency. Sometimes that means negotiating with the Crown around the duty to consult and accommodate. And sometimes that means negotiating with proponents to negotiate impact benefit agreements. So the other side of my practice involves litigation. And there I do a lot of litigation around Section 35 rights, which we'll talk about today. So Aboriginal and treaty rights, and trying to protect those rights on behalf of First Nations. And most recently, I'm actually just getting out last week out of a 1.5-year long trial representing Saugeen and Nawash First Nations on the Bruce Peninsula in Canada's first Aboriginal title to water case. So, and there I had the distinct pleasure of working with Ron, who was one of our experts. So that's it for me. Happy to be here.
Thanks, Renee. So my name's Adam Chamberlain. I'm a lawyer. Sorry, there's a couple of us around today. I work in a large law firm called Gowling WLG, and Gowling has offices across the country and does the things that large law firms do: corporate law, litigation, various different things, and in various different cities, as far east as Montreal and as far west as Vancouver. My own practice is sort of sits in two places within the firm. I sit is in the environmental department in Toronto, and that's my day job. But so I'm an environmental lawyer, and it's through environmental law that actually I came to be exposed and to deal with Indigenous issues in Canada as a lawyer, having spent a bit of time on a reserve with my father, who's a traveling doctor, back when I was a kid. I came to the environmental law and started being exposed to, well, it was when I'd be on projects. Most of our clients were trying to get projects built. And often, this is 25 years ago, the local First Nation or Indigenous organization would show up and they'd have their lawyer with them. And I was the one who seemed to get engaged. So I've been doing it more and more ever since, to the point where my practice is probably, well, better than half Indigenous related, and the other parts of it largely environmental. And what I think makes my practice also interesting to me anyways, is that it is not just in Southern Ontario, it's kind of split. I'd say Ontario is probably half of my practice, and the other half of the practice is Indigenous and environmental and resource work in the territories, in particular in Nunavut, but also in the Northwest Territories and the Yukon as well. So I get this, normally I would be on the road for a week, a month or so. And normally I would have been, while I'm talking to you today, I might be in Iqaluit, or I might be in somewhere else, another community. Of course, for the last 7 months since we switched to daylight savings time, I've been, and now back, I've been sitting in my house in Toronto. So that's my practice. Normally geographically, it's quite diverse, not so much this year. And then finally, I would just say that my clients tend to be pretty broad group, actually. In some instances, and in particular in Southern Ontario, I work with either developers or government agencies, private landowners, consultants, archaeologists, municipalities, dealing with Indigenous issues of a variety of types. But outside of this part of the country, it's a bit different. And I work for instance, the government of Nunavut. I do a great deal of work for that government, but which is largely Inuit based, but is still a civil government, but created, interestingly, by a modern land claim. We can talk about modern land claims later. And then other clients I do work for are Indigenous. And so I have the pleasure of working, for instance, for an Inuit organization called the Kivalliq Inuit Association, and it's one of the 3 regional Inuit associations in Nunavut. So mine is a practice that sees me working with Indigenous and non-Indigenous players, which is, I think, really interesting. So that's it for me. Sorry I've gone on so long.
Well, I think we can all be glad that we've snagged a little bit of time from you two to talk about things today. I think we should start at the beginning. Renee mentioned this, and just define for our audience who may not know, what are the difference between Aboriginal and treaty rights, and when did they appear in Canadian law? And I think something that people think about a lot is what are the differences between what we call Canadian law and Indigenous law, and maybe touch on the sovereignty of nations as well, how that works in law. maybe Renée, you can start and feel free to talk about that tiny topic.
Yeah, that tiny topic that could last several hours. Okay, I'll touch the highlights, then maybe pass it over to Adam to fill in where, the things that I'm sure I'll miss. So I think the important thing to start off with is both Aboriginal treaty rights, which are different, I'll explain the differences in a minute, are constitutionally protected rights. So Indigenous groups have certain rights that are protected by the Constitution. So 1982, Constitution comes around, Section 35 gets created, and so the rights that Indigenous people enjoy are supposed to be sort of safeguarded, right, as against other rights. And some of those rights are rooted in the pre-sovereignty practices. So those are Aboriginal rights. So Section 35 Aboriginal rights are the rights, those activities which an Indigenous group engaged in before the Europeans came. And there's sort of a complicated test to establish what rights get Section 35 protection, but some of the cases that have gotten a lot of, high profile things that we typically think about are like hunting and fishing, harvesting rights, those kinds of things are the more obvious ones. And so kind of the way of life of Indigenous people, if you were, prior to sort of contact with Europeans. And then the other kinds of rights are called treaty rights. And those flow from the agreements that were entered into, not by all First Nations, and we can talk about that at some point, but in those First Nations or Indigenous groups that entered into treaty with the Crown. So when the Crown, when the British asserted sovereignty in Canada and were trying to sort of develop Canada and sort of come in and take over land, there were Indigenous people here that had to be dealt with. And so they entered into treaties with those people. You also hear about a lot of court cases about the interpretation of those treaties. You have treaties on the East Coast that were peace and friendship treaties that did not purport to surrender land. So they were really about sharing and about like living harmoniously. So those did not, as the court says, extinguish Aboriginal title. And then sort of the more west you get, when you get to Ontario, there were a number of treaties that the English version of the treaty purports to surrender land. That was not the First Nations understanding by and large. They understood that they were entering into a sharing relationship for the most part. But those treaties tended to also afford certain rights. So the treaty would say, you can continue your usual hunting and fishing practices, but we will be allowed to develop these lands and we are going to reserve certain reserve lands for you. And so those are treaty rights. A First Nation can have both. You can have a First Nation who has entered into a treaty and it doesn't mean that it extinguished all of its Aboriginal rights. So basically, if something isn't covered by a treaty and it was a pre-sovereignty practice of that Indigenous group, that is said to have survived. Maybe I'll park it there before getting into the difference between Canadian and Indigenous law, because otherwise I'm going to feel like I'm rambling too much, and see if Adam has anything to add to that.
Sure, Renée. Maybe I'll talk a little bit about what has changed in the last, I'd say, I guess 30 years or so, because it kind of it touches on some of the things you've just mentioned in terms of the number treaties. And you were getting towards, but didn't quite get into a detailed discussion of modern treaties. But there are modern land claim agreements, and these have really come up since, frankly, I started practicing law. So I've been doing it for not quite 30 years, more like 25. But when I went to law school, it was different landscape in Ontario. When I was in law school and we were studying Aboriginal law, we were taught that essentially the numbered treaties, that is, the peace and friendship, and then the numbered treaties covered much of Eastern Canada, and then got into same on the prairies and largely, and into sort of getting into the north, but not really. The Nunavut didn't exist yet. The Inuit didn't have a land claim. There were no modern land claims in the north yet. And then BC was, pardon upon the Wild West. There was no treaties, and yet there were many First Nations with claims. And so if you were talking to, and I had friends who were members of First Nations, both in BC and in Ontario, and interestingly, listening to them back then and talking to them again now, you get slightly different angles, because back then my friends who were members of First Nations in BC bemoaned the fact that they didn't have treaties, and this was a big issue, that BC and the federal government hadn't ever come to the table and properly negotiated with the First Nations there, and so they felt hard done by, quite rightly so at the time. There's been a move, and there's still lots of First Nations that haven't settled, but there's been a move, and there are some modern land claims that have been settled now there. And there have been, frankly, the big difference, if you were to look at a map of Canada, is that the Arctic is just covered with modern land claims. And it's not to say all the First Nations or Indigenous organizations have settled with Canada. There are several in Yukon and Northwest Territories that have not, but it's a different way. And now, actually, what's interesting is that you start to talk to the people in Ontario who, back 25 years ago, First Nation friends of mine would say, well, we have a treaty. They might not think it was implemented appropriately or being adhered to by Canada or non-Indigenous Canadians, but they had a treaty. Now, frankly, many of them look at the modern treaties enviously because the modern treaties are more modern. And so they tend to reflect, I would suggest, current sensibilities, which are a little bit more enlightened than they were perhaps back roughly 100 years ago when some of the number treaties were negotiated. So things have changed, and this is a theme that you see a lot in this space. The way that non-Indigenous Canadians have come to understand our relationship with our Indigenous brothers and sisters has changed, and it continues to. Expectations have changed dramatically, and sadly, though, you still see a lot of things that are clear evidence that things have not been settled. And you only have to point to things like the lobster fishery right now, which I know most of us have seen in the last few weeks. And you see an example of a situation that has not resulted in a peaceful coexistence the way we would hope to see. So this is an area of great flux and change. This isn't new. I hope, and by the way, I'm non-Indigenous and I'm very clear about that. But I would consider myself an ally who works in the space, and so I personally would like to see things continue to evolve in a positive way. And it's difficult because these are very challenging times, and we can talk about them more. But there are a lot of smart people who have not been able to come to the table and really solve things, and so it's going to take time. And I'll stop there for a second, perhaps, Renee, as I'm starting to drift a little bit as well, and maybe hand it back to Ron or you.
Well, maybe I'll just take those answers for a moment and just, I think probably in the audience's mind, in the individual audience member mind, it may be we remind them that all of Southern Ontario is basically treaty land. What are those treaty rights that people have to be aware of? When we say we're living in Toronto and we've got Treaty 13, I know they vary from treaty to treaty, but generally, what can we tell people? What are those treaty rights? Renee.
So they're all different, and there are numerous treaties in Southern Ontario. Some of them are quite small and are kind of like smaller land surrenders that happened kind of after the Royal Proclamation of 1763. And then sort of the further north you get, kind of the treaties kind of deal with larger swaths of land. So they all are a bit different. A lot of them do contain the language that I referenced earlier around sort of safeguarding Aboriginal, the fishing and hunting and gathering sort of as they always have lived. But I think more importantly, a community's treaty territory or traditional territory, the rights that we need to be aware of are the rights to have a say in what happens to that land, right? Because oftentimes, one of the things that I see a lot in my practice is working for a community, and there's a particular project or some sort of development where the community isn't contacted because either the proponent or the government at the time has determined that, well, there's not an obvious impact to your hunting, fishing, trapping. Let's say it's something that's happening in an area that's developed, and it's not an area that the Crown or developer assumes that a First Nation is using, right? So just to be careful not to make those assumptions, because basically all development can have some impact on either, or virtually all development can have some impact on either a treaty right, sort of the more traditional way of life kind of rights, or Aboriginal rights, which can include things like the right to protect your heritage and your archaeology, right? And so I think a lot of the development that we see in urban centers where there may not be an obvious impact to hunting, let's say, can have an impact to archaeology, and that's a Section 35 protected right as well. Adam, did you want to chime in on that one too?
Yeah, I think the one thing I might add to it is just the notion of the spectrum. The courts have weighed in on this and tell us that there's a couple of things we have to think about. One is whether, and we'll talk about the duty to consult and accommodate, we'll talk about it some more, but it's a responsibility or a duty that the Crown has, that is the government has, Canada or Ontario in our case. And when determining whether there's a need to consult or accommodate with Indigenous, or the legal term is Aboriginal, but I tend to use the term Indigenous these days. But if you're determining whether there's going to need to be consultation and accommodation made or contemplated, you have to think about a spectrum. There's a couple things you have to think about. You have to think about the nature of the right, the treaty or Aboriginal right, and whether it's, I don't like to use the word insignificant, but less significant, let's say, or more significant, and that is going to depend. It's very factual, fact-based analysis. And then, so there's the question of that spectrum of the nature of the right that's being affected. And then there's the nature of the effect. And so, for instance, if you're building a 8-lane highway through land that is either part of a reserve or close to a reserve, or close to land that's in dispute or subject to claims, well, a large highway it's not rocket science to figure out. Let's say it's through, and also let's say it's through a forest, so it's not through farmed land, or it's not in municipally developed land. Then you can see how that would be a significant impact. At the same time, if you're talking about rebuilding or building a light rail transit system down King Street or Queen Street in downtown Toronto, well, that's going to have very less significant impact. You can still dream up situations where there is archaeological materials underneath a road, but you're less likely to see massive changes. So you have to think in terms of this. And so the reason I raise it is because I think it's important to understand that it's not always black and white. And the question about when do we consult, what do we consult about, and how much do we do that is going to change depending on the facts that based on that spectrum, or those spectra, I should say, that I just described.
So one of the questions that I get constantly in my practice is, who are the agents responsible for engagement? If it's the Crown that made these contracts with Indigenous nations, is it only them? That means the federal government and the province. What about municipalities, creations of the provincial government? And what about developers, landowners, and even the general public? What roles do all of these people play in this? I know that's a huge question, but I think you guys are up to it. Renée.
Never an easy question from you, Ron. Yeah, so ultimately, that's right. I mean, the duty is owed by the Crown, but the Crown can delegate that duty. And so maybe I can say a little bit more. Adam said already a bit about the duty to consult, and it's important for us, I agree, to remember the spectrum. Can I launch in now, Ron, to how the duty is triggered? That might be helpful in answering this question. Okay. So when the Crown contemplates any kind of decision that has the potential to impact an Aboriginal right or interest, it owes a duty to that Indigenous group or First Nation whose right might be impacted of consultation. And so those decisions can be the decision to issue a license or permit. It can be, anyway, things that any kind of decision the government might make. But it's not always the government that procedurally discharges that duty. So the duty to consult and accommodate has two components. There's a procedural component and a substantive component. And the procedural component is often delegated to proponents and sometimes to municipalities, right? If the municipality is the one making a decision to grant a permit or license, some people have argued that that is a procedural delegation of the duty to consult. So ultimately, and this is something else I see in my practice, is sometimes we have really great proponents, developers, what have you, who are happy to, who see the benefit of getting on board, getting a community on board and meeting with them early and addressing their concerns, whether the duty has been officially delegated to them or not. They just see that for their project, it makes sense, and I commend those people. And then you have some people who are like, I've been told that the duty belongs to the Crown, not my problem. Well, what happens then is, unless the Crown is going to go and meet with that First Nation about that developer's project, then the duty's not going to get satisfied and the project's not going to go ahead. So we can sort of, there's sometimes some debate about whether the duty, the procedural duty, gets officially delegated or not. But in my experience in practice, the Crown often does look to a proponent to say, okay, it's your project. Have you met with this community? Have you addressed their concerns? And then the addressing of concerns is the other part of the duty. So there's the procedural aspect, which involves things like making sure that a community has enough time to review documents, to provide comments. It can involve funding. That's something that the court has recently said, that funding can be a part of the duty to consult, the procedural aspect, to make sure that consultation is meaningful. And then there's the substantive. At the end of the day, have the concerns raised by the Indigenous group been substantively addressed? And ultimately, the duty isn't met until the concerns of that First Nation have somehow been addressed. I'm sure, I don't even know if I answered your question at this point, Ron. I feel like I've gone off on a duty to consult and accommodate spiel. I forget what the question is. I'll turn it over to Adam.
No, but that's perfect, because it leads into Adam and I first met on York Region's, one of York Region's big projects. And the question at the time was, what duty does York have versus, so go ahead.
Yeah, and that in particular, that was in 2006. And for those of us who work in this space, there are a few dates that matter. And 1982 being a big one, when the Constitution came and Section 35 was implemented or created, I should say. But 2004 was a date that's important, because it was a date that some cases came from the Supreme Court of Canada that really set out a lot that we now know is the law around the duty to consult and accommodate. HIDA was one of the cases, and if you were looking for links to those cases, they're not hard to find, but we can always provide you with them. But so the reason I mention this is that in 2006, when Rod and I were working on this project, it was a large piece of sewage infrastructure, strangely, very large. And the question was, what do we need to do? Do we need to do outreach to we didn't know what it was. Do we need to do, or nobody really knew. But by then we had cases that were 2 years old, so still fairly young. We hadn't really seen a lot of people implementing the recommendations of the courts in those cases, but we did. And so we looked at that, and that was an interesting case, because in that case, the municipalities were a proponent. It was 2 municipalities, large upper tier municipalities. And so the question was, well, do they have the duty to consult? Well, the courts had said that it's a Crown that has the duty, but then a few things happen. One is you can undertake a legal analysis, and I won't bore you with that now, but there's a very practical question. If you're the municipalities, or if you're the proponent of some other project, and you're wanting to do something, and you need a government permit or approval, or an environmental assessment approval, well, then you're going to have to go through that process. And that decision to approve or not a project is going to trigger the duty to consult, right? Because if the Crown is allowing a project to be built, and it's being built in a way that impacts or has an effect on Aboriginal or treaty rights, then the Crown certainly has the duty to consult or accommodate with respect to that project. And sitting as the lawyer, as I was at the time, for one of the proponent municipalities, I didn't really care too much about. It was an interesting legal question, but I wasn't too worried about whether there was a legal duty for the municipality to do it, because frankly, at the end of the day, if the project ends up being attacked in court by the local First Nations or Métis or other Indigenous organizations, then the project's not going forward, because it can't, it's stuck in court. So as the part of the team that was trying to get the project built, we looked at it and said, oh, well, if we foresee a potential for problems down the road, so how do we avoid that? Well, the way you avoid it is you get out, you do the consultation yourselves. And you do the things that I like to say you treat people the way you'd like to be treated yourself. So for instance, in that case, these were Southern Ontario First Nations, but a lot of there's been a lot of change in who has been living in Southern Ontario over the last centuries, and some not long ago, for 400 years or so ago, more, there were the Huron-Wendat were here. They're not here anymore, living here. They're in Quebec City, and I believe, Ron, there's some Huron-Wendat in Ohio, but I may be wrong about that. But they're outside of Ontario. So one of the things we did, for instance, is we went to the Huron-Wendat, the community that called Wendake, which is in Quebec City, and we visited and consulted with the members of the council there, the council, the First Nation Council, and we translated the documents into French because that's the language they spoke. So we did these things to make sure that we did what we were at the time might have called outreach. It's consultation. And just because we did it didn't mean we could check a box and go on with the project. There has to be a meaningful consultation that results in understanding of the project and a meaningful dialogue about the project. And the project had some things in it that addressed concerns of the First Nations and of the several First Nations that were consulted. So all that is to say is it's a process that is not always the same, but it has to be meaningful, and it has to be one that is that, as I say, I think treats people the way you would if you were them, you'd want to be treated. So a few thoughts, and I'm starting to wander now in my comments.
Sorry about that. What I'd like you to turn your minds to is something that's happening frequently. Adam, you mentioned the millennia of occupation of Southern Ontario and the various nations that have occupied Southern Ontario. Hence, we have land parcels that are within the treaty territory of some nation or nations, but it's also the traditional territory of nations. So this is a kind of gray area of law, I know, but can you guys speak to this issue of, in that kind of situation, kind of what's the strength of the interest and the need to accommodate when it's traditional territory versus it's the treaty territory of a nation? So I'll go over to Renée now.
Sure. So sometimes, maybe I'll first start off by noting that sometimes those two things are the same, right? The traditional territory and a treaty territory are synonymous. So there's no confusion. But as Adam mentioned, I think a very good example of where they are different is a group of First Nation that Adam just talked about, which is the Huron-Wendat, who were historically in Ontario and then relocated to Quebec. And they have what is said to be the richest archaeological history in Southern Ontario. And so they are a group that I think for a long time went ignored, because even when developers would start, recognize that, there's this duty to consult and they have to meet with the local First Nations, typically you go to the local First Nation. And so archaeology was being uncovered that didn't belong to the local First Nations. It was the heritage of the Huron-Wendat in Quebec. And so I'm happy to report that they are now being engaged on development in Ontario. But that would be an example, Ron, of where you have, Mississaugas of the Credit, for example, Toronto sort of and environ is their treaty territory, also, the territory that they live in today. Their rights that would be impacted by development would be different than the Huron, right? So I don't want to purport to speak for them, but presumably they would have a large interest in, environmental concerns, that sort of thing, their current use of the territory, how development might impact that. Whereas if you have an archaeological site, there is a Section 35 right to the protection of that, provided that that's something that was the sort of catchphrase in law is integral to the distinctive society of the First Nation sort of at the time of contact. So in the Hurons case, they have a very rich history of protecting particularly their dead. They have very remarkable burial practices that they have a spiritual responsibility to protect the bones of their ancestors. And that, from my perspective, qualifies as a Section 35 right, a right that's protected. So from my perspective, that is just because they're not in Ontario, it doesn't weaken the right in any way. They may not have as strong of a right to where there's impact to hunting and gathering, for example, because that's not something that they're doing in Ontario. But when it comes to archaeology, like to the spectrum that Adam mentioned before, it would still be very high on that spectrum for consultation.
Yeah, maybe I'll just say that sometimes the notion of traditional territory can be quite confusing, and often it's most confusing to the non-Indigenous members of communities or organizations who are trying to do things. And I'm thinking a little bit of where you have overlaps, because we live in a big province, but it's not so big that people don't live near each other, and we talk and we were taught a lot about non-Indigenous history when we were kids, at least I was. But there's a lot, there's a rich history of Indigenous occupation of this, not just Ontario, but the whole of North America. And it's not static. So it's not like one community or one group lived in one place and didn't move. They moved a lot over the generations. So you can find situations where different communities both claim, and rightly so in many circumstances, that their traditional territory occupies a certain space. And that can be complicating, because it can mean it's confusing about who you want or need to talk to about those things if you're consulting with the communities that occupied a particular area. And there's sometimes overlap, sometimes different views. Indigenous people are human as well and don't always agree about whose traditional territories is whose, or where the lines are. And actually the lines often intersect or overlap. So I'm not saying this with a view to resolving uncertainty. In fact, I think what I want to do is just make it clear that there is some uncertainty about this. And again, I come back though, when I'm faced with this uncertainty, or with the question about whose traditional territory is what, the answer is not often crystal clear. And it's a question that I think one has to approach with an open mind to hearing all sides of it, and then understanding that not everybody's going to agree on the outcome of the discussion. And then, you're going to have to work through whatever issues or project or thing is requiring the consultation. Of course, that's going to have to be layered over onto this. But it's why, when you have especially large projects or large undertakings or large decisions of government, that there's going to be more than one Indigenous organization that's concerned about it. Sometimes it'll be the whole province or the whole country. Other times when let's say it's Southwestern Ontario, well, I can think of more than a dozen Indigenous organizations that are going to be concerned, or at least want to know about things happening in Southwestern Ontario, to determine whether they think they ought to be consulted or not. And that's just the start of the discussion. So, and that is not only about traditional territory, but those questions revolve around the question or the issue of traditional territory and treaty territories, and being able to at least contemplate and think about what's what.
Okay.
Confused you, eh, Ron?
No, it's a good answer, because it's so confusing for all of us, really, and complex as we try to navigate that. I think one thing that our clients often ask is, who is it that we're supposed to be consulting with and engaging with in regards to projects? And we can offer that. It's rarely one nation, it's usually more than one nation. And then we run into this issue of governance in some nations and the complexity in governance. And if you were to give general advice to people about with whom to engage and how to find out about that, what would that advice be? Go ahead, Renée.
So I will say that I consider myself to be very fortunate to not work for too many communities where that's a question mark, because it's complicated. And it was really brought to light with the Wet'suwet'en, issue from was it a few years ago now, a year ago, where you heard in the news there was this traditional government and then the Indian Act government or the elected government, and sort of who had a right to say what happened to its territory. And so there are some communities that have traditional forms of government and have also band councils that are elected under the Indian Act. And there are some communities that have both of those and recognize both, right? And that there are certain decisions that are made by the traditional form of government, and there are certain decisions that are made by the chief and council. And then you have some communities where one doesn't recognize the other, right? And that's where things get really messy. In Ontario, you don't see too much of that. I think that in BC, that tends to be like a bit more common to have those two forms of government within communities. Six Nations is one community in Ontario where that is the case. It's not just a chief and council elected under the Indian Act. But many communities in Ontario, all the ones that I work for, I also work for a number of communities out east. There's one sort of leadership, and it's very clear kind of who you would go to. So, I mean, my advice would be if you are a proponent and are being told by the government, municipality, that you need to engage with the local First Nation, would be to ask them, and then to when you contact. Typically, the sort of first point of contact is the elected chief and council. Would be to ask, and my hope would be that if you're contacting a community that also has a traditional form of government, that they would advise you of that. I think typically where there's a community that has both, you tend to find out pretty quickly. So I think if you were on the wrong side of that and were not engaging with who you were supposed to engage with, someone would let you know pretty fast. Yeah, I'm not sure, Adam, if you have more to say about that.
I think he does.
Yeah, I have come at it through different angles. I think, Ontario in particular, in Southern Ontario, when I've been involved in where this question has come up, usually I've been working for either municipalities, consultants, companies that are wanting to build infrastructure of various sorts, sometimes some residential developers. And so if you're in a place where there is a very clear delineation of who to speak to, and I'm thinking of projects that are frankly further north, outside of the deep south, as I like to call it, it's usually a little clearer. So if you wanted to build an energy project and you're, I don't know, in Northern Ontario, well, typically there's going to be one or two, maybe First Nations nearby, the Métis probably, and you're going to have to engage there. So typically it's fairly obvious. That having been said, even there, you sometimes see, what I might sometimes be called splinter groups or factions within communities. And as Renée says, it's about talking to people and asking, who do I speak to? Because that's how the only way to learn, really. And there's different people to ask. I mean, you can ask, there's usually consultants on the ground, but you're really, at the end of the day, the people you sit across the table from, the First Nations or the local Indigenous community members, whether they be Métis or First Nation, you're going to have to ask them, and you'll get varying levels of agreement about who you might speak to. Where it becomes a little bit more difficult and challenging is when you're in a place where there is a lack of agreement among the Indigenous community about who to speak to, and that does happen sometimes. I have to say I'm surprised it doesn't happen more. Based on my experience, there's times I would expect to see it that I don't, but it does happen. And when it happens, and it's already been mentioned that Six Nations has a traditional government as well as a formal Indian Act government that's the one recognized by the Crown. But increasingly, with the way the law has been changing, there's an acknowledgement that we don't just deal with or consult with the Indian Act recognized band, but we're also talking to the traditional forms of government. And I think that in the case of Wet'suwet'en out in BC, which by the way was only 7 months ago or so, but just because of COVID seems like an eternity ago. But there, what you saw was, I think, clear evidence that the government hadn't been talking to people. And now I'm not saying just because you go and talk to somebody, it's easy, you get a resolution. But if a conversation is going over years and continues, then typically you can see at least some development of, if not consensus, a mutual understanding. And eventually you did see it happen very quickly last year when there were blockades and things happening all around the country, again, pre-COVID. You know, that inspired, we saw meetings happening with government ministers, with the Wet'suwet'en traditional chiefs, and that was something that hadn't happened until then. And so I think what has been tricky for government, and I feel for some of the individuals in government, I'm not always as understanding for the apparatus of government, but as an individual working in government, like a particular minister or deputy minister, it's hard to navigate these things, especially when you earn a living by dealing with day-to-day problems. You don't always think about stuff that has been boiling or simmering for generations and turn your attention to it until something big happens, like the dispute that led to those blockades. And then we saw action. I wonder though, if you went back and spoke to Wet'suwet'en now, whether they would tell you that the last 6 months has seen as much action and back and forth discussion. I don't know, maybe it has. I don't know, but it typically, these things typically follow when stuff gets hot in the news, it gets attention. And that's a bit of a function of our government, unfortunately, that just the way it works. So it's a challenge. Anyways, back to the issue of the distinction between the traditional and and Indian Act bands. I mean, this is a point of contention and complaint, I will say, by many. And it's a fair complaint, but it's really reflects a lack of understanding of the reality on the ground. Having worked in the space and worked with Indigenous clients and Indigenous counterparties for a couple decades now, it doesn't surprise me when somebody says, "Oh, you've got to go talk to the clan mothers, or you've got to go talk to the traditional chief." It's just about learning that. If you don't know it, then you're going to be stepping all over people, and it's going to be difficult. And in some cases, where it's particularly frustrating, I think, and what I see with projects is when you've got a big project that's got lots of money behind it and costs a lot to do, there's lots at stake. People don't typically get too concerned about spending an extra $1,000 or more here or there, maybe it's more than that, to engage with a group of people. Where you're a developer building 2 houses in an area where there's dispute about, and maybe it's because there's heritage, maybe it's because there's human remains, but there's a dispute about who you talk to, and you're looking at, 2, 3, 4 houses, and that doesn't give you a lot of wiggle room to spend money to do things. And that's where it can become very challenging. How does somebody who's really got a fairly small project engage? And for that there are no simple answers. Interestingly, the people who I look to for guidance are the Indigenous people who are involved, often the archaeologists, people like Ron and other professionals, people in that profession, because they are regularly speaking to the people on the ground. So they typically have a sense of who do you have to talk to. And occasionally people like me or Renee will know. But even for us, I mean, for me, if I'm getting pulled onto a project because of lack or concerns around consultation, usually the problem is already festered for a while, and so I'm not usually the person you call to say, who do I talk to about these few houses I want to build in such and such a community in such a part of the province. Usually it's somebody on the ground, a member of the community, somebody who's been doing archaeology in the area, that kind of thing. So those are some thoughts on that.
Great, Adam, thank you. I do want just to stay with Six Nations for a second, just because it provides us with a good example. I want to go back to land claims for a second. In the Haldimand Tract, we have a number of claims that have been registered with the federal government, specific land claims. And I remember when Douglas Creek Estates happened, kind of the original Caledonia, not the one that's happening right now as well, but getting a question of, well, why isn't this registered untitled? So can we just talk about claims for a second and that process? And then we'll move to UNDRIP and FPIC. We're getting towards the end of our hour, but I want to cover those topics, but that we can deal with in just a few minutes. But let's talk about claims for a few minutes. So I'll go back to Renee.
Okay, so I will say that sometimes claims are registered untitled. So the Aboriginal title to water case that I just finished the trial for is an example where we were claiming, the two First Nations were claiming Aboriginal title to the lake, the beds of the lakes. They had not been ceded or surrendered by treaty. So the argument there was that Aboriginal title remained, and those lands are currently held by the Crown. But after they launched their claim, there's sort of a treaty component. Anyway, I'm not going to get, it's very complicated to sort of get into the nuances of this trial, but basically after the claim was filed, the Crown tried to, or was wanting to divest itself of some of its land. And so basically transfer land to third party, which would have had the effect of taking it out of the claim. Because in this case, the two First Nations were only claiming land that was held by the Crown. They were not trying to displace third parties, homeowners, for example. And so what we did was through consent, we would negotiate what are called certificates of pending litigation. So basically on those tracts of land, the First Nation said, okay, we're fine for you to transfer this little tract, provided that the person who is coming into sort of ownership of this land is put on notice that in the event we are successful, we're going to be asking for it back. So that is something that's possible. I have to confess, I'll maybe look to Adam to see if he knows more about the specifics of Six Nations. My understanding is it's not necessarily Crown land, which is perhaps why there's been no attempt to put things like CPLs on title. But I'm going to put you in the hot seat, Adam, to see if you know more about the facts on the ground than I do.
I don't know the facts specifically about why the approach has been taken or not, actually, more to the point with Six Nations. What I will say, though, is that there's a bit of a spectrum on this, with this issue across Canada. There are parts of the country, and I'm thinking British Columbia more actually than Ontario, where you do have things on title. Occasionally, I've been asked by real estate companies or large owners of real estate who are historically owned tons in BC and we're looking to buy some stuff in Ontario, and got this call once saying, okay, so we went looked on title, there's nothing there. We ran the search, there should be something there, because they knew that there was a First Nation in the area and this particular thing. So the practice in BC is different than it is here, and so I think you'll see an evolution of it. I think you're going to probably see more of a move towards that, because people want to get some notice of what is going on with the land. One of the things I will say about Southern Ontario is historically, claims haven't resulted in large amounts of land moving. Now this is changing, right? And Renée has given an example of how a case she's been involved in recently. But I'm thinking a little bit, for instance, about the Mississauga's claim, which was resolved with Canada, or at least one of the claims that was resolved with Canada not too long ago. And they made a point in the material that I would see explaining to the public their claim of saying this was not going to result in the transfer of land of, I'm sitting in a house in Toronto, for instance, and my house was not going to get transferred back to the Mississaugas as the new credit. But they made it clear that they were looking for something from the government, and that something was largely going to be money. I think that's frankly a practical reality where you're sitting in the middle of Toronto. It's going to be very unlikely to see it move. Where you're talking about water in Lake Huron or Georgian Bay, it's a different question altogether, because you're kind of in the commons there. It's not Crown, well, it is Crown land, it's Crown water. So it's capable of being dealt with. And I think that this points to a practical reality of these discussions. Is often there's a need to understand what's happening, and understanding to do that, you need to know the context. So I'm not really explaining or able to answer the question about why we don't see it on title here, but there is a federal service on this interesting thing called the internet, with which I am now seeing you all, or you're seeing me, that you can type in your address. And I haven't used it actually in about a year or two, but I know people who do frequently. But this is a service on the federal government's website where you can put in a location, you can be told, and maybe Renée will remember the name of that, which I'm forgetting right now, but you can find out if there's claims. The thing that I always worry about, and this is the lawyer in me, I don't trust somebody else's views about where there's a claim or not, because if you looked for a claim on the case that Renée is talking about 10 or 15 years ago, my guess is you'd not find it anywhere. Now it's of course well known. So these things change over time, and in particular, when it comes to the evolution of claims, some claims that frankly have been either seen as dormant or in research stages, haven't really been pushed hard until recently, or maybe in the future sometime. These are things that will, if you looked on the title right now, you'd certainly see nothing. Maybe 10 years from now, you would see something. So I don't typically trust too much about what I see on the web. What I typically want to know is about the history of the area and learn about that. And that's a deeper question that is not easily answered. And one, I think, Ron, you may not remember it. I think the first time we met was once I heard you speak. It's got to be maybe 6 months ago. And you asked me, or I asked you, I want to learn more about this. I understand the issues, but I need to understand, how do I learn the history? Because the history seemed to me to be the key to it all. And so I've been on a quest for the last, well, I was lying, it wasn't 6 months ago, it was about 20 years ago. But I've been on a quest since then to read everything I could about this. And frankly, there's more and more being written. So it's hard to keep up, but I would encourage people who are trying to figure out a particular, that's the status of a particular region, to think more than just about what's on title, what's on the government website, but also what's in the history. And sometimes that's not easy to do.
Thank you for that, both of you. We have about 5 minutes before the Q&A starts, so I'd like to conclude with a bit about the Declaration on the Rights of Indigenous Peoples and a concept called FPIC. People know it as FPIC, which is free and prior informed consent. Before the last change in government, there was a provincial initiative to begin talking with municipalities about free and prior informed consent as it related to land use development, land use change. I suspect that's been suspended for the moment, but I guess the question I would have for you, the question that I know I heard from municipalities was, does that mean veto? And I know, Adam, you know, I've had a conversation once or twice about this, but where are we now as we kind of survey both Ontario and, if you like, across Canada in this whole notion of FPIC? Was there not some movement on this in BC? And what does that say for us here in Ontario? So maybe Adam can start this time and I'll go to Renee.
Sure, happy to. So first of all, free, prior, and informed consent is a concept that comes from, from international law, and it's really got its genesis in a document called the United Nations Declaration on the Rights of Indigenous People. And this is an international document that was, I think it's pretty safe to say, it was created to address concerns in different parts of the world where Indigenous people's rights were being not paid attention to. And, you know, this is happening in different places in different ways. And this notion of free, prior, and informed consent is a notion that is in the Declaration that essentially says that where significant changes are going to happen with respect, and I'm paraphrasing in the extreme, but where there are going to be significant impacts on the lives or rights of Indigenous people, that they should be, those Indigenous people should have rights related that are described as free, prior, and informed consent. So this is a notion that before the thing happens that, you know, destroys a community or has substantial impacts that on their way of life or what have you, that they get the chance to understand what's coming and give some consent. Consent is a word that means different things to different people, and it means it sounds in one way, it can sound like a veto. It can also sound like, and I don't think it is a veto in this case, just to be completely clear, what my thinking is. But it can be also something that's about, I don't know how, I don't have the really wording that I would use that I've got as a pat answer to this. But I think it's more about, is there a conversation going on? Is there a constructive conversation going on? And does the community have the ability to have significant impact into that discussion? So, and I think that's where I would say the discussion takes us. Not everybody agrees with me, and I'll be interested to hear what Renee has to say about this, but it is an area of some disagreement. It's also something that is going to be interesting to see how it overlays into the Canadian context, because British Columbia, for instance, has passed legislation that is effectively something you'd call it enabling legislation. So it says that the UN Declaration and FPIC are going to be considered in the context of all BC law. And so that process, it's a process though. It's going to have the BC government setting up this process where they're going to have to analyze their legislation to see if it does comply with the FPIC and the rights in the declaration. Canada is also moving in a similar direction. They haven't introduced the legislation yet. There was a private member's bill that I think was lost with the last election, or maybe the prorogation of Parliament. And in any event, the government is aiming and moving towards a similar piece of legislation that would require that FPIC be considered and in the context of Canadian law. And so that's the direction we're going in. I think it's an open question what that means and what the implications are, because frankly, lots of people, some of them judges, others might say that frankly, our law already, by creating this duty to consult and accommodate, may already do to a great degree, if not entirely, maybe less so, what FPIC and what the declaration is describing. So I'm going to stop talking for a second because I've said a lot, and I'm going to let Renée chip in here because I think, as I say, I suspect we may have slightly different takes on some of this. I'm not sure.
Okay,
yeah, so I think I hear the veto question a lot, and what I encourage people when I get this question is to try to look at things differently. So the point of the United Declarations on the Rights of Indigenous People, and specifically with the article around free, prior, and informed consent, is to recognize that Indigenous people have a right to a say in things that impact them, that they, particularly here in Canada, we're sovereign nations, that to a large extent they still are, and we're trying to recognize those rights in Canadian law. They're recognized in international law, and so by Canada, by kind of signing on to the declaration, that's what we're trying to do here in Canada. And so when people say, well, does consent mean veto? To me, if you look at any municipality, municipalities are a form of government, as are First Nations, and they make decisions. And so if the city of Toronto is deciding whether or not to issue a permit, to agree to a permit, to agree to a permit or granting some sort of authorization, no one accuses the city of Toronto of exercising a veto, right? It's exercising its governmental powers. It's exercising its decision-making authority. And so to me, that's kind of what FPIC means, right? It's about governments, Indigenous nations, making decisions about whether to agree to something or not. Now, that doesn't mean, and so I guess why I also think that the notion of veto is misplaced is governments in Canadian law have a obligation to act reasonably, right? So going back to my city of Toronto deciding whether or not to issue a permit example, if the city of Toronto decides not to approve a development for no reason, because it says we decide to say no today, and they can't justify that, well, you can take the government, you can take the municipality to court, right? You can do what's called a judicial review and review that decision. And so anyway, my take would be, similarly, First Nations or Indigenous groups also have a duty to act reasonably. And so that's, I would encourage people to look at it that way as opposed to veto or not. These are governments exercising their decision-making authority.
that's a great answer. Thank you.
Yeah,
I'm going to turn this.
Excellent, thank you.
I'm going to turn this over to Morgan, who is now going to moderate the question and answer period. Hi, Morgan.
Hi, Ron. Thank you so much. So to those I haven't met, my name is Morgan Peters. I'm the Manager of Operations at Shared Path Consultation Initiative. I've been monitoring the Q&A and looking at everything rolling in. There are a lot of questions to get to. We're not going to get through all of them, so we're going to use the voting process to decide which ones to ask first. So the first one, the top voted one, comes from Mitchell A. And Renée and Adam, he's asking if you can speak to the cumulative impacts of development on Aboriginal and treaty rights. So as we've been realizing, the duty to consult and accommodate has only begun to be defined in the end of the 20th century. What about all those decisions, development decisions that were made before? And what about decisions today, and how are we considering how far into the future it will be impacting Aboriginal and treaty rights? Things like, for example, climate change. So who would like to take on that big question first? Adam, would you like to try that?
Yeah, you tend to hesitate taking yourself off mute because you know you're going to start talking. Yeah, it's a tough one. I mean, I think if you keep it if we keep the question to a manageable level, because I think when you start to say climate change, and I'm happy to talk, but it would take for a long time to talk about climate change. For instance, I do work, as I said earlier on, I do work for an Inuit organization. You can imagine that their view about climate change and the implications of it for their culture are quite dramatic and stark. So that is a very long discussion. I think when I think about, in the context of this discussion, maybe I would just be a little less ambitious and try and say a little bit about cumulative impacts as I think of them as an environmental lawyer who works in environmental assessment from time to time, that you're looking at, you know, the concern is that there could be death by 1,000 cuts. So one project may have nothing to do or very little to do with what rights or what, whether it's rights or what part of the natural environment is affected by a project. You take 1,000 similar projects and it's a big thing. And so how do we do that? Well, I think we're still just getting really accustomed to the question about how do you do that in a government approval point of view. And so I think there's still some distance to go before we figure out how to deal with it entirely. I do think that, though, the question of if you're looking at it, if you're doing the analysis from the point of view of who is giving, who is doing the thing that requires consultation. So for instance, let's say there's a particular area in the province and right now it's pristine or close to pristine, but then next year somebody builds a mill and next year somebody builds a residential development and so on and so on and so on. So over time, the government is going to have to turn its mind to this because every time it gives an approval or sets up a system that creates approvals for this particular theoretical area, there are going to be more impacts, not just on the natural environment, but also on Indigenous rights in the area. And so I think it is a question, if you're doing environmental assessment, you are supposed to be looking at these cumulative impacts. And I'd suggest increasingly, we're going to have to think a little bit about how do we bring that analysis to an Indigenous set of facts. And I don't really have a good answer except to say I think it's something that's it's really just at the beginning of something that we're having to work through, and it's going to take time. So that's my way of starting the discussion about that one. It's not an easy question to answer, I don't think.
Yeah, I don't know if I would have too much more to add other than, I mean, I do sometimes, I feel for proponents who are particularly in the environmental assessment context, who are, you know, coming into an area that is developed and where, you know, First Nations were not consulted and their territories gotten eaten up by development. There's hardly any land left. And, you know, and they're told, well, you know, your project is the straw that broke the camel's back, right? And that's crappy. And I feel for them. I think I've also seen proponents though try to be really proactive, right? And recognize that, you know, I'm thinking of one particular case back out east where this particular project was going to have impact to fish habitat. And the proponent was like, come on, it's like one small area, like what's the big deal? But it was like the only area, you know, it was like one of the very few areas that was left. And so, so what the proponent did was, they got into an agreement to, you know, try to rehabilitate a different area, right? To try to make up for some of those cumulative impacts. So yeah, it is unfortunate that it's often sort of all put on the shoulders of some people at the expense of others, but that is the reality we live in now. And yeah, I too feel like we could talk about this for a very long time.
Yeah, and I'll just finish it by saying I think the complaint lays at the feet of the government. And I don't mean today's government, but successive governments in the past that haven't done what they need to do to manage these issues in particular areas. Not a very helpful answer, but I think unfortunately it means that it's important to engage with our politicians and governments to see that these things get more attention as time goes on.
Absolutely. I think, yeah, project assessment is ill-suited to be dealing with these issues, and you know, things like you know, like regional planning, land use planning, regional assessments, those kinds of things I think are needed to properly address issues like cumulative impacts. And that's just not
where you and where you are, you know, and I do find myself occasionally being the lawyer for the project proponent who is the straw that broke the camel's back. Typically, some of those projects have been built, and with not consent, but with the willing participation, I would say, of Indigenous partners, often joint ownership too. So I think the other thing that we're seeing increasingly is people saying, okay, so we've tried everything. And I've had clients say, come to me and sit in my office and say, we've done everything. There's nothing we haven't tried, and they won't agree, and they're making our life miserable, and it's really hard. And I'll say, well, have you thought about this and that and the other thing? And often a little bit of outside the box thinking can get you there. And some things, and now if you're a municipality building a sewer, you're not about to give away equity in your sewer. But if you're building something else, there may be opportunities for joint ownership. Municipalities have other options, and they're not, sometimes they're about, making sure that there's appropriate recognition in the municipal boundaries of the Indigenous heritage in the area. I've seen that happen sometimes. Other Indigenous communities will say, well, that's inadequate, but at least it's a start of a conversation, and who knows where you go with it.
Yeah, thank you very much, both of you, for tackling that large question. And it would be great at some point to get some of those examples that you're alluding to and kind of work through them maybe at a different event to talk about, those, how the proponents and Indigenous communities and municipalities, everybody involved, kind of worked through a solution. So I'm going to get to our next question, which was upvoted while we were speaking, and it's about the provincial policy statement in Ontario, the PPS 2020. It's about section 1.2.2, which says planning authorities shall engage with Indigenous communities and coordinate on land use planning matters. So are you seeing this being implemented today? And what is the risk if municipalities and developers do not meet this test?
Well, I'll take myself off mute just to say, first of all, I don't have an answer. I haven't seen it being used. So I can't really answer the question directly in an informed way, except to say, what is the risk of not doing what is put in the policy statement? I'd say the risk is that you end up with projects that don't have legitimacy in the eyes of the community members, and in this case, maybe the Indigenous community members I'm talking about. And what does that mean? Well, it can mean different things. In certain circumstances, it can result in self-help remedies, blockades, things like that. But in the vast majority of areas of disagreement, it has nothing, doesn't look like that at all. Those are just the ones that hit the mail, hit the newspapers or the internet for that matter. But it does mean, though, if you have disagreements, it does make life difficult. So I would suggest that complying with requirements that encourage or require Indigenous consultation is good business. It's good practice, and it is something that ought to be done for reasons that aren't just about avoiding very negative headlines.
I know there's a ton of questions, so I'll just quickly add that I think particularly where our archaeology is involved, I think it's really important for municipalities to be engaging, like where municipalities are sort of expanding and proposing sort of like development to otherwise undeveloped areas. What I think is frustrating for First Nations is when someone goes to actually put, shovel in dirt, and that's the point at which they're getting engaged. Meanwhile, there's like an entire plan for a subdivision that's already been approved. And a lot of these sites are known, right? Like, sometimes you happen upon things and we get, like that's understandable, but where there are sites that have been registered, communities really need to be engaged on that. So I think with archaeology, especially municipalities need to be talking to communities.
That's a great point. Thank you, Renee. And also, Ron Williamson, who's been moderating, has actually put together a quick guide for municipalities around consultation in archaeology, and we put it up on the Shared Path website, so I'll share a link to that later. So let's move to the next question that has been upvoted. So this is from Andrew O'Brien, and he's asking, why is it the case that a great deal of development projects in Southern Ontario appear to proceed without any consultation with affected Indigenous communities? He says these projects clearly have implications for Indigenous rights and treaty rights. So I know we've touched on that a little bit in some of the previous discussion, but did either of you want to kind of comment on that?
I mean, I just simply quickly say that I think it's because the rules didn't require it. So, you know, if you're a developer, typically most developers I know are responsible. They follow the rules. They hire lawyers, they hire consultants to make sure they get the appropriate approvals, and they do. But what we're talking about are things that are still, we mentioned before, I was talking a bit about it, that this has been an area of great change recently, and this isn't, and it will continue to be a great area of great change. I mean, the guidance, or what is it? It's just gone out of my head, but the requirements for consulting archaeologists, for instance, what are they called? The guidelines and standards, I think they are. There's some of it's permissive that says that you should do these things. Other things are mandatory. You have to do these things. Well, that is only from, I think, 2011. I think, Ron, is when the most up-to-date version was published. Before that, if you were a consulting archaeologist, it wasn't nearly as clear what you had to do to keep your license. So things are changing. They have changed. They will continue to change. But why things have happened that you might look and say, why have they happened? It's because they were allowed to happen, right? And that's not necessarily always going to be the way it is from here out.
Thank you, Adam. Anything to add, Renee?
No, just I think I mentioned earlier that sometimes I think the people who are making the decisions about where consultation is needed and where consultation is not needed tend to have a kind of, oh, will this impact harvesting rights kind of approach to things, and often will forget about things like archaeology. So yeah, I think it's always best practice to engage and engage early if there's a risk. And I think with archaeology, there's almost always a risk. I mean, I suppose sometimes there isn't, but where there is that kind of a risk, it's better to engage, even if not absolutely required, because you can avoid problems later on.
Morgan, I'm going to add just one comment, which is that most of the GTA is now covered by archaeological management plans. And in those plans, where archaeology is required is clearly outlined. And there may be areas that did not require archaeological assessment, and therefore engagement with Aboriginal communities may not have happened. And so it is possible that more dated developments occurred without Indigenous engagement, even though the PPS is not speaking only to archaeological engagement. It's a more broad requirement, more in line with Section 35 rights, I would say. So, okay.
Right. And so the lesson that I'm taking away from this is engage early, start building relationships early. Don't try to make the call on your own about whether this will affect, whether these decisions will affect harvesting rights or whatever it may be. You know, contact the Indigenous community and see, or Indigenous communities that will be affected or might be affected or have some kind of Aboriginal treaty rights for that area. So the next question is about, once you reach out to these communities, how do you handle, as a municipality, how do you handle any requests for financial support to undertake review or studies? And are there legal obligations to do this?
So I'll take that one, if that's okay, Adam, just because this was finally the question of whether part of the duty to consult, whether it's delegated or not, includes a funding component, was decided by the court, I want to say 2017, in a case that my firm actually did. So Saugeen First Nation and Nawash Unceded First Nation and Ontario Ministry of Natural Resources, and it was a case involving a quarry. And that was basically it was a situation that I unfortunately see far too often in my practice, which is quarry operator was told, you know, before getting its license that it had to engage with the First Nation. It met with the First Nations. In this case, there were 2 impacted, and said, okay, tell us what the impacts of our project are. What are your concerns? First Nation was like, we don't know very much, like we don't know very much about quarries. We don't know what the impacts are going to be. We'd like to conduct some studies. And quarry operator was like, sorry, we're not going to give you funding. And then kept meeting, and just this loop, right? Like, tell us what your concerns are. We need to do the studies to tell us what, you know, to be able to identify the concerns. Anyway, so finally it ended up in court, and the court did say that, we've talked about the duty to consult and accommodate, and consultation has to be meaningful, and that there are circumstances where, in order for that consultation to be meaningful, funding is a requirement. So it is not unreasonable. What I also try to tell proponents when they kind of grumble about this is, look, this is your project, right? The First Nation does not benefit from having its land impacted by your project. So why should they be expected to spend their money and their resources when they get literally nothing out of this, right? And so the very least you can do is provide some funding for, for their time, for any studies that, any experts they need to retain, that sort of thing. So yeah, so I really do think that, and there's nothing wrong with requesting that a First Nation provide a budget, and that it be that there there be some basis for the money. It has to be a reasonable request, of course, but funding, I think, is really, really, really key. First Nations are stretched so thin.
Yeah, and I would the only thing I'd add to that is that there is this element of reasonableness. There's no expectation that First Nations or Métis or Inuit get a free, blank check that they can just do whatever they want. There is an element of reasonableness that the courts typically have inserted into these discussions. And while that may not be a good thing or enough to really be helpful to a small proponent, to a large municipality that has to do these things, frankly, there's enough known by people who do what Renée and I do, and consultants who Ron does, and others who do this, that it's not outside of what I think is reasonable to be expected of, I call them reasonable business people or reasonable municipal leaders. This is an area of business now. This is a cost, an element, a cost of doing business is working this that has to be considered is how does a proponent or a municipal decision maker, or for that matter, a different government, how do they work this into the process? It's part of life. It's not, so, 15 years ago when somebody would complain about it, I'd say, yeah, this is really hard. Now when somebody complains about it, I typically say, well, this is part of doing business in Ontario or Canada actually. And most people, I see lots of projects being built, and lots of projects being built with the informed participation of Indigenous communities. So it's something that we can do. But you have to think about it up front. If you wait until you're 80% through your project before you start to think about how you're going to manage this, it's very expensive from a time and money point of view. If you work on it from the get-go, it's a lot less of an impact on the bottom line usually.
Great, thank you both. I'm going to go to a question that actually Adam kind of alluded to earlier, or started to get into earlier, the difference between modern treaties and the treaties that happened earlier, such as the Peace and Friendship Treaties, Robinson Treaties, all of those. Could you explain some of the main differences between modern treaties and the older ones?
Sure. The most simple difference is that they're modern, so they're new, and so they have the benefit of learning from the mistakes of the past. And so they, typically address things like, how do we govern ourselves? How does the community govern itself? Because Indigenous communities now don't really just want to be told, here you can live in this reserve, and we'll give you this much money, and this is where you will be. They want a stake, a real stake. And it's in the case of businesses and big projects and energy projects and stuff, we are now starting to hear more and more about joint ownership, having Indigenous co-owners. But in the case of the modern treaties, they create more than that. They create governments that are essentially run by and for the Indigenous populations, and in some cases, such as Nunavut, for instance, where Nunavut was created by the modern land claim, the Nunavut Land Claims Agreement, or the Nunavut Agreement, and but it created a civil government. So I'm a non-Indigenous person. I'm certainly not Inuit, but if I was to move to Iqaluit tomorrow, I could vote in an election for Premier of Nunavut. So it created a modern institution a set of institutions of public government, and that's what these modern treaties do more and more. And they also typically are on a larger scale than a small community. So typically be a large area. And if, in particular, if you look at the Canadian Arctic, you'll see 4 or 5 very large modern land claims in place there. And that's so they're an aspect of their existence is that they're very large, but not all. There's some in BC that are smaller areas that have resulted in a form of self-government as well. So the modern land claims, more about how to govern, not about push and pull between the Indigenous and non-Indigenous residents later on. At least that's the way they're designed. Renée, I'm sure you've got something you could add about that.
No, in the interest of time, also, but also I think that was perfect. I don't think I have anything to add. That was great.
Well, great. And I do want to respect your time. So before we wrap up, do you have any last thoughts you'd like to share? Maybe we'll start with Renée. Is there any kind of last message or thoughts you'd like to share with us?
Oh, geez. No, I mean, I think just to hammer home some of the points that we've already touched on today, particularly around engagement. I hope that the message was received that, whether you officially have to consult, whether you've been formally delegated the duty, it's just always a good practice to engage with impacted communities about your, whatever it is that you're wanting to do that has the potential to impact their rights. I think that's just a smart kind of business decision to do. And I think that it sort of pays off in the development of relationships, right? I have a lot of clients who have worked with some really good proponents, and that proponent has come back for a second project later on, and it goes so smoothly the second time around, right? Because that relationship has been developed. So I don't know if there's anything else I'd add. This was really fun. I feel like we could have gone on for maybe 5 more hours. But yeah, I'm just really, really happy to have been able to participate in this today.
Thank you so much, Renée. And maybe we will get to bring you back and continue the discussion at some point. I mean, because like you said, we could go on for a long, long time. Adam, do you have some final thoughts?
Yeah, just a couple. I'd say 2 different types of final thoughts. One is that I noticed, because I pushed on the Q&A button, that there's lots of very specific questions that we haven't even come close to. And that's just a fact of time. And I looked at a couple of the questions and I thought, boy, I'm glad I'm not answering that one. It's hard. This is an area that is not simple, and it's not. There are very few answers that are questions that are easily answered. It's not which kind of leads me to the second element of what I wanted to say, and that is that's not shouldn't be seen, I don't think, as a reason to give up or throw your hands up and say in despair and say, well, we can't do anything here. Far from it. I think that there's lots of ways of approaching things. There's lots of ways of dealing with people, rolling up your sleeves. Typically, as I think I said before, if you treat people the way you would want to be treated yourself, at least in terms of the nature of the conversation, you're probably going to get a decent hearing. It may not result in agreement, and it may not result in everybody, being best friends, but at least you'll have a conversation. Just like Renée said, I mean, if the municipality says I can't build an office tower where I want to build an office tower, I'm going to react a certain way. And if it's an Indigenous community that's saying we don't want you to build such and such a thing, or they want things from you to do it, step back and say why. Ask yourself why, and start to think about, perhaps put yourself in their shoes if you can, and just think about what you might be able to do to resolve the situation. Typically, you're not going to find the answers in your own head. You're going to have to talk to other people. And so I think whether it's the people on the other side or other people in your team, the best solutions typically come when I hear them from other people, I find. So, I'd encourage people to be open-minded and reach out to others when they're trying to find solutions, because there are many, but they're not always easy to find.
Great, thank you for those thoughts, Adam. And I liked what you said before also about learning the history, continuously looking back and trying to understand the context and the bigger picture. So with that, on behalf of ULI Toronto and Shared Path, I want to thank Juan for leading this engaging conversation, and I want to thank Adam and Renée for sharing your wealth of knowledge, your wealth of insight and experience with us today. Shared Path has prepared some resources to support your learning, which are publicly available through our online resource database. So I referenced a few, and we put a few in the chat, but so one of the things we put in the chat was a 2-page background on treaties and treaty rights. And then I'm going to share a link to some case summaries, and some more information about duty to consult and accommodate. There are also some examples of First Nations consultation protocols. So if you want to see those, they are publicly available on our website. We're still building our database, but there's lots of resources to get you started, and that's sharedpath.ca. And further, in the spirit of reconciliation, we ask that when you access these resources, that you consider supporting Shared Path by making a donation. We are a charity, and our mission is to facilitate and support Indigenous and local governments, institutions, and organizations to navigate the challenges of an emerging reconciliation landscape through research, education, relationship building, and resources. So we're hoping to create systemic change and respond to the calls to action put forth by the Truth and Reconciliation Commission in 2015. So if you're able to, please help us with this work by making a donation. And feel free to reach out to Ron or I if you have any questions. Ron is the vice chair of our board. So with that, it is time to wrap up the session. So miigwech, niawen, marcy, thank you for joining us today.